Can your employer just pass you around without consequence? This man worked for 14 years as a messenger, only to find out he didn't even have a real boss.
This is the case entitled Palic Conjusta versus PPI Holdings Inc. et al. GR number 252720, August 22, 2022.
This is case 12 of 160 cases decided by 2024 Bar Chairperson Marvick Lopez. Subscribe for more reviewers.
Facts of case. Rico Palic Conjusta was hired by PPI Holdings Inc. PPI, in 2002 as a messenger. His employment was later transferred to a manpower agency CBMI. Despite the transfer, nothing changed in Conjusta's work. He continued as PPI's messenger for 14 years until CBMI terminated his services in 2016. Conjusta filed illegal dismissal against PPI and CBMI. PPI denied having an employer-employee relationship with Conjusta, asserting that CBMI was a legitimate job contractor. CBMI acknowledged Conjusta as its employee but denied terminating his services. The labor arbiter ruled that CBMI was a legitimate contractor but Conjusta was PPI's regular employee. The NLRC modified the ruling, declaring CBMI as labor-only contractor, making PPI and CBMI solidarily liable. On certiorari, the CA reverted, ruling CBMI as legitimate contractor based on stare decisis.
Issue of the case. Whether the CA erred in ruling that CBMI was a legitimate job contractor and Conjusta's direct employer.
Ruling. Yes, the court ruled that CBMI was engaged in labor-only contracting based on the circumstances showing PPI's control over Conjusta's work. PPI and CBMI were deemed solidarily liable as employer and agent respectively.
Doctrines of the case. One, declaration in previous cases that a company is an independent contractor is not conclusive basis to determine its status as such in another case. 2. Totality of facts and circumstances in each case must be assessed in determining if entity is labor-only contractor. 3. Certificate of registration as independent contractor is not conclusive proof of such status. 4. Where contractor does not exercise right to control employees' work, it is considered labor-only contracting. 5. In labor-only contracting, principal employer and contractor agent are solidarily liable.